Hi everyone, thanks for joining us today. This is Rana from CCASA and I'm with Lydia
Woligorsky from CCACV. We are both the public policy directors for the organizations.
And today's webinar we're going to be talking about forging new pathways to safety for survivors by looking at ways that we can engage the systems that survivors find themselves in after victimization. So to kick this off, we are going to do like a couple of little bios. I think if you're joining us today, you probably know us and have been to some of our webinars or the LEAD event or conference, but just to put a face to a name. And then we are going to talk about our 2017 policy priorities for both organizations. So many of you may know that the way we set our policy priorities is what we lovingly refer to as bottoms-up advocacy, meaning we look to you as the experts in the field, as those individuals who are working with survivors on a daily basis and who may be coming into barriers with different systems as they attempt to provide survivor-centered services to the folks that we work with, the folks that wind up in shelters, the folks who we respond to in the middle of the night on those crisis calls. So in keeping that in mind, we want to think about what are the different systems that survivors find themselves in. And that is a product of this year's, or that question rather, is a product of this year's policy priority setting, where we're really looking at domestic violence survivors, what happens when they interact with medical professionals? How does that increase their safety, or does that cause risks for their safety? And looking at juvenile sexting crime, now we're talking about wandering into digital spaces and online platforms. How can we ensure that juveniles are safely navigating digital communication? And then last, we're going to look at the Housing Protections for Survivors bill, where not only are we accessing the criminal legal system to help survivors with housing protections, but we're also expanding that to include advocates as part of that solution and to include medical professionals. Because again, we see that criminal legal system is not the only place that survivors find themselves in after victimization. And so we really need to look at this as a holistic approach to providing safety options in every avenue that a survivor may have to walk down after victimization. Also, if you look at this slide, these are all hyperlinked to the 3 different bills that Lydia and I are going to be discussing today. And let's jump into mandated reporting for domestic violence. Lydia, do you want to take this?
Absolutely. Thanks, Rana. And so, and as Rana said too, we know that survivors are actually pretty darn smart and in some cases absolutely brilliant in the ways that they navigate their own safety, and survivors have become very skilled and adapted at navigating between their life-generated risks and their batterer-generated risks, and some of the smartest, most creative people I have ever known have been people that I have worked with through my advocacy career. And so recognizing that survivors are the best people to help navigate their own safety needs. They are the best people to know the actual moods and things that are going to set their batterers off. They are the best people to know what works for their lives as they try to find their way out of an abusive relationship. We have presented this bill. So currently, if you go to a medical licensee, which is defined in their statute as physician, physician assistant, and anesthetist, and they are treating an injury related to domestic violence, they are by law required to report this to law enforcement. And we have ran up against several cases and several instances where this has actually created more harm for the survivor. We know that it takes time to enact a safety plan. It takes time to find a safe place to stay, whether that be emergency shelter or to save up money and get out on your own somewhere. It takes time to figure out what is going to be safest for you in terms of, do I file a protection order, do I not file a protection order? survivors navigate these very tricky and complicated situations for their own unique circumstances every day. And by forcing someone into a law enforcement report at the time when they seek medical care can really jeopardize their plans for their own safety. And so we want to give survivors autonomy to be able to work with their medical providers, not against their medical providers. We absolutely want survivors to seek health care when they need to seek health care. And we want to let them be able to do that without having to fear a law enforcement response. Now this year, with everything that is going on in the current political climate, we especially want survivors that are undocumented to be able to seek health care and access. And if I'm an undocumented survivor and I believe that if I go to my medical professional, they will be required to call law enforcement, I'm not going to seek medical care because I can't take that risk for myself or for my family. And so this bill would do a couple of things, right? So certainly it restores a self-autonomy and dignity for adult survivors by creating an option for them to work with their medical provider. But it also says that if I go to my medical provider and I tell them I am choosing not to report at this time, that medical provider is then required to document the survivor's wishes into the medical file. It is already best practice for them to document why the survivor is there, any injuries and that sort of thing in terms of what they're seeing. But then it lives in the medical file. It also requires a physician or a physician assistant or anesthetist, a medical licensee under statute, to refer that person to a confidential victim's advocate, right? So a couple of things with that. It allows people to get their injuries and get things documented in the medical file, and then it allows them to access immediate resources. And so we know that best practice will certainly be for them to allow the survivor to use the phone, to call somebody up in a program, to call the national hotline if their program is not available for some reason, and to speak immediately to an advocate into that safe space, which is the doctor's office. We know that that is certainly best practice. We know that having a doctor or a medical provider being able to work with you is actually proven to shorten the amount of time that a survivor stays in an abusive relationship. In fact, they are 2.6 times more likely to exit that relationship quicker if they have this level of support. And so this is a way for people to gain access to resources. It allows them to work with their physician. And back to our undocumented survivors, it allows them to document their injuries, to seek care, and then when they are ready to go into, when all survivors are then, if they become ready to go into a civil courtroom procedure or a criminal courtroom procedure, that documentation will be there for them. Once they are ready to enact a safety or contingency plan and they have a safe place to go and they say, okay, now I want to file for divorce and custody, but I didn't go to law enforcement. I don't have this documentation, even though I know this is going to be important in my case. Under this bill, they will be allowed to get that information from their medical file. They will be allowed to present that in court if they need to present it in court. And so we think that this will actually strengthen both civil and criminal prosecutions in the future as people are able to document things. Right now, if I go to my doctor and I lie about my injury, and then that medical file, it comes up, and I'm now found to lie about my injury, I am a liar in the court. And that does not help me as a survivor when I am trying to gain custody of my children or when I am trying to go forward in a criminal prosecution. So we want people to get care, period. We want people to be able to be honest and truthful with their doctors, period. This in no way prohibits or hinders their ability to contact law enforcement. This in no way allows physicians to ignore the injuries created by domestic violence. This is not a full repeal of the law. This is a half measure that restores autonomy. This is a half measure that says the doctor is to document injury and to provide resources. So it's in the file. It will be there for them when they're ready. And we really want survivors to be able to seek care no matter what. And so We've heard from folks in our shelters that people have on multiple occasions come into shelter, and the advocates and everyone knows this person needs to go to the hospital, needs to get medical care, and they won't do it because they're afraid of a law enforcement response that they're not ready for. And so being able to say to survivors, you have the right to take care of yourself, you have the right to seek medical care, is really important. And we've been working on this for a couple of years now, and this is the year that we decided to introduce the bill, and largely that was because of what we're seeing with our undocumented folks. There's a lot of pressure to keep working on this and not go forward this year, but knowing that we have large members of our population in Colorado that do not have a safe place to go has really wanted us to take this bill forward this year and to work on it. So here's some more information about why we need these changes. And basically, we know that it takes time for survivors to put these contingency plans in place for themselves. And always, when a woman or a survivor reports to law enforcement, it is only a beginning of another process. It is not necessarily the end to the abusive behavior. The abusive behavior might look differently when somebody has gone through a criminal prosecution, but there is still a lot of emotional and physical and very difficult safety mechanisms a survivor has to navigate even after someone has been arrested, especially if they have children together. And so we also know that changes in bond schedules typically mean that offenders are out 24 hours, 36 hours after an arrest, and that's not enough time for someone to be able to find safety for themselves, right? We want to give them time, we want to give them safety and support, but we will not allow them to be forced out of talking to their medical providers any longer. We have several organizations that have signed on in support of House Bill 1322. There is still time to contact us and have your organization added to this fact sheet that is now circulating. I believe we go to hearing on April 20th, which is next week. So yesterday we had Planned Parenthood of the Rocky Mountains as well as the Women's Lobby sign on in support of this bill. And so even if you are listening to this webinar and you are not part of our membership organizations, if you believe that women and survivors need care no matter what, we certainly ask you to take a look at this bill and just be educated on what is going on in your state. Okay, well, thank you, Lydia, for that update. We're going to move into now the juvenile sexting crime or juvenile sexting bill. And we've been talking about this for about 2 years now, so I know that everyone is maybe getting sick of me continuing to have this conversation, but we haven't yet settled on a solution. So until we do, this is going to be a running conversation, at least from this office. Because, and what this slide tells us is what the problem is. And the problem is that currently in the state of Colorado and many other states too, there's no appropriate charge for the crime of abusive or malicious juvenile sexting. And right now, the only tool that our prosecutors have in these types of cases is the felony exploitation of a child statute, which carries with it sex offender registration and sex offender treatment and sex offender management. And it's everyone can agree that that is not an appropriate consequence for what many would believe is an exploratory behavior that juveniles, and even like, let's think about this generation of teens. These are young people who have literally grown up on screens, who are having a simultaneous parallel process of adolescent sexual development. Is it possible that these teens
who have grown up on screens and that adolescent sexual development may intersect. And where those things do intersect, how are we as a society going to handle it? And I think that's the biggest question plaguing many General Assemblies throughout the country. And this little snippet here at the bottom is from the 2016 legislative report by the Colorado Division of Criminal Justice, where it talks about how do we find or define that bright line between harmful behaviors. I believe this report uses terminology like sexually deviant behaviors, but how do we define abusive sexting versus exploratory sexting versus consensual sexting versus sexting that rises to the level of a felony? There's lots of questions, and what we are seeing this legislative session is two bills with two very different solutions. So we're just going to get into those bills and what each is proposing. So a little context for this conversation. In the 2016 legislative session, House Bill 1058 was introduced. It was named Misuse of Electronic Images by a Juvenile, and upon first blush, we thought that it was a good idea because it created a non-felony, lower-level misdemeanor crime for juvenile sexting. But I think probably Lydia can agree with me that in policy work, the devil is in the details, and taking a closer look at what that bill suggested, we thought that it cast a net so wide it captured more than criminal behavior, and in fact had the ability to adjudicate or punish victims of privacy violations, consensual activity, and abusive behaviors. So we attempted to work with proponents of the bill and bill sponsors to bring these concerns to their attention and try to find a way that victims would not be charged with a crime that was actually designed to protect them, but had the potential to prosecute them. And we couldn't land on bill language, we couldn't find a workable path, and so for that reason CCASA chose to oppose the bill. The bill died in committee, and that bill has resurfaced with a few changes, and this year it takes the form of House Bill 17-1064, highlighted in red because we have many of the same concerns we had with House Bill 1058. This is the same bill title, Misuse of Electronic Images by a Juvenile. Many of the same provisions from the bill that we killed last year and the same proponents of the bill. But also, in the interim, CCASA gathered with a robust group of stakeholders, which now is totaling over 30 organizations, and we tried to take our perspective in finding a policy solution for abusive sexting in Colorado. And so what we ended up doing was bringing together a lot of folks at the table, and I mean, I'm talking unusual allies, where the victims' rights organizations are working in collaboration with the defense to compromise and, again, incorporate as many systems as possible. We talked to school officials and law enforcement officers from Canyon City who leveraged the Canyon City sexting incident, that high-profile sexting, what the papers called scandal, in 2015. We talked to survivors and victims of abusive sexting. We talked to peer leaders in schools all throughout the state. We talked to CCACV and Colorado Parent Coalition and the Colorado PTA, and we tried to incorporate as many voices as possible at the table to produce what we think is a really well thought out solution to juvenile abusive sexting in Colorado. And so just taking a look at this slide, this is showing us the difference between the two bills and the impact on victims. So 1302 separates abusive forms of sexting and creates lower level misdemeanor crimes for abusive sexting. And in creating those very narrow definitions for what is abuse, it prevents a victim from getting caught in that net. Whereas in 1064, there is no discernment, and that net, again, is cast so wide that it captures more than just criminal behavior. In taking a look at how both bills stack up with the ability to charge teens as felony sex offenders, what House Bill 1302 does is creates felony carve-outs. So it says that only under certain circumstances can a district attorney charge the felony exploitation of a child statute in sexting cases. So an example of that would be if a juvenile were videotaping the sexual assault of another juvenile. That, we believe, rises to the level of a felony charge.
Yeah.
Lydia. Lydia agrees. Another example would be if a juvenile has a picture of another juvenile and posts that picture to a porn site for profit. We believe that that behavior rises to the level of a felony. So there's in these most egregious cases the ability to charge the felony, whereas in 1064 there is no carve out, and so essentially it doesn't really fix the problem, we believe, because it allows because there's no clear definition about what consensual sexting is, what a victim of sexting is, what abusive sexting is. It allows in any sexting incident for the district attorney to press either the felony or the misdemeanor charges without having any sort of guidelines. So we believe that felony carve-out is a better approach, is a more thoughtful approach, and again, is the product of a year-long engaged and extensive stakeholder process with folks like the Criminal Defense Bar and Juvenile Defender Center at the table helping us to create those guidelines. In looking at how the bills differ between education and restorative justice resources, the most simple answer is that 1302 offers education and restorative justice and 1064 does not. So 1302 tasks the School Safety Resource Center with creating a sexting curriculum. That way schools who want to provide their students with sexting education have an easy go-to resource where they can access those materials and hope to educate kids on what the potential long-term consequences of sexting behaviors are, in addition to educating kids on what their rights are. So for example, both bills have a provision that if you are the unsolicited possessor of an image, you have 72 hours to delete the image and you will not be held criminally liable. So the unsolicited possessor looks like this. You've got kid A sends a picture of themselves to kid B. Kid B then further disseminates that picture of kid A to kids in the plural, C's in the plural. Well, kids C's didn't ask for that image. They just received it. So should a juvenile who doesn't ask for an image, who receives an image, should that juvenile be held criminally responsible? Under current law, they are. But under both bills, they would have a 72-hour window to delete the image or report it to either like a school official, a law enforcement official, an SRO, and they would not be in trouble. And we had to balance that with, does that unsolicited possession feel any less like a violation of privacy to the victim, to that student A who knows that their picture is in possession of all the student sees? Does that feel like any less of a privacy violation? Not really. So that's where the 72-hour timeline came from. But this curriculum that the school safety resource center is tasked with breaks that down for kids so they know if I get a picture what their options are and what the consequences of holding on to that picture might be. And also, another component is the restorative justice, where juveniles who do exhibit that abusive behavior. So in the example that I just gave, it would be juvenile B or student B, the person who violated student A's trust, the person who further disseminated the image when there was an expectation of privacy, the student who did not have consent to distribute that image. That is who we would consider an abusive sexter, and that juvenile would be eligible for restorative justice programs if that were available in their district. House Bill 1064 does not provide for any of that. It only utilizes the criminal legal system as a tool to influence juvenile sexting in our state. So again, this is supported by a variety of different organizations. And as Lydia mentioned before, if you have an interest in this bill, if you want to talk about it more, then please feel free to contact me. Our contact information is at the end of this PowerPoint, so stick with us. And I think we'll flip over to housing protections for survivors. So maybe Lydia, so this is a bill that Lydia and I both worked on. I would say that it was co-championed by both coalitions because it really had a significant impact on victims of domestic violence, sexual assault, and stalking, where currently in Colorado, can you tell us what the domestic violence provisions were until this?
Absolutely. So currently in Colorado, a landlord was not allowed to discriminate against you if you had to call law enforcement to protect your own safety. And so we had something in there that said you could not sign a lease that would violate your right to this. And so a lot of leases out there have nuisance ordinance clauses saying if you call law enforcement X amount of times, you'll be asked to leave your apartment. And we knew that even though this was in law, landlords were trying to find ways around this. We also had in current law that if you needed to break your lease as a domestic violence survivor, you could take to your landlord a copy of a police report or a copy of a protection order and say, I need to break my lease, and you would then be responsible for 30 days more of rent, and would they were supposed to let you out of your lease. And having to have a copy of the police report takes time to get that copy of the police report. Some departments will not release things if there's an active investigation, that sort of thing. Some departments also charge for that information. A copy of the protection order, we know that sometimes it's safer not to do the protection order, right? And so again, it comes back to listening to survivors. What a novel idea. And so having these be the only two documents that would be allowable under this law, you know, was a great idea, but it was also a barrier for a lot of folks. And we want to make sure that anything that we do in the law are solutions for all survivors, not just survivors who feel safe enough to report to law enforcement, but all survivors, which is really kind of the theme that most of our bills fall on this year. And so House Bill 1035 takes that into consideration. And it takes into consideration by expanding the documents that a survivor can present to their landlord. The current law only applies to domestic violence survivors, and so this expands it to survivors of sex assault and stalking as well. And so now, once this passes, if you are a survivor of sex assault, stalking, or domestic violence, you would qualify to be able to get out of your lease if you needed to get out of your lease, and it expands the documentation that you can provide to your landlord to prove that you were experiencing victimization. And that expansion, we got really creative and fairly broad, and I'm actually really proud that was able to pull this off. And so what it says is that, you know, you can have a letter from an application assistant through the address confidentiality program saying that you are a survivor, and that would qualify. You can have a letter from a medical professional, not just licensee, but professional, and statutorily there's a difference, a medical professional to say you have sought care or treatment for any one of these 3 crimes, and you should be able to use that with your landlord. You can still use police reports, you can still use protection orders, but for all survivors, there are now these additional pathways. And so the address confidentiality program, just to clarify one thing that we've gotten some questions about, you do not have to be enrolling in the address confidentiality program. And people use that program in a variety of ways, right? But you don't have to be enrolling in the program, although honestly, if you're seeking to relocate for safety reasons, you might want to consider it. But the application assistance can be found in you know, domestic violence programs, sex assault programs, district attorney's offices, law enforcement agencies, all sorts of places. The address confidentiality assistants are broad and wide and open and are well trained on how to document this. And so we allow them to be, and encourage them to be an additional pathway for safety for folks.
And I think, too, that this bill is a prime example of what we're talking about when we are trying to engage all of the systems that survivors find themselves in after victimization. And so if our goal is to help find safe housing for survivors and their families, then how are we doing that? Well, this bill allows medical professionals to be a part of that solution. It allows advocacy programs to be a part of that solution, and it allows law enforcement to continue to be a part of that solution. So we hope moving forward that this is the continued work of the coalitions, where we're not solely relying on one system, but we're really taking that holistic approach to meet all of survivor needs, because, you know, surviving domestic violence or sexual assault is a complex, you know, process.
Long-term.
Right, long-term process, and we need to be providing as much support as possible for all survivor needs, and I think we accomplish that in this bill.
Agreed.
These are the organizations who have signed on. Where this bill is at, it's passed in both chambers, which is pretty exciting. And I think overall, there were only 3 legislators out of 100 who voted against this bill.
And these were the 3 that just kind of generally vote no on things.
Yes, yes. So overwhelming support by, you know, the entire state house really is what this bill saw. And it's currently held up in conference committee. There was a last minute amendment tagged on, and so we will keep you updated on the progress of this bill, but we think that it looks pretty good.
Yes.
And that next steps, you're going to see Lydia and I doing like a tour of the state with a point of advocacy on how we can ensure that our advocates are implementing this new piece of legislation. And I think that's it from us.
I think that's it. So we are less than 30 days away from the end of session. And as stressful and as wonderful as that is all at the same time, so things are going to move pretty quickly. And so keep posted for action alerts and from communications from Rana and I that will let you know about these bills. We also, it is a lot easier and quicker for us to get action alerts out on social media than it is to actually sit down and write something in MailChimp. So please like us and friend us on Facebook. Follow us on Twitter. We are CCACV1 and Lydia in Colorado, and you are at CCASA I think you're just at CCASA in Colorado. So certainly feel free to follow us, send us an email, or give us a call, and we absolutely look forward to being in touch.
Absolutely. And if anyone has any questions about any of the bills that we talked about today, please feel free to reach out to either Lydia or myself, and we can get you some good information on the status of the bills and answer any other questions that you may have. And I think Josh is going to close us out. Is that right? Okay. Josh, you're on.
Well, I just want to start off by saying thank you, Rana. Thank you, Lydia, for all this wonderful information and for all the wonderful work that you all do. This is Josh, the Training and Technical Assistance Coordinator for CCASA, and I just wanted to end with giving you all updates about the upcoming webinars through CCASA for this month in April. On April 20th, there will be a webinar at 12 noon with regards to understanding the reporting options for sexual assault survivors. And then on April 24th at 12 noon, CCASA staff will be looking at the connections between rape myths and sexual assault reporting dynamics. So I hope you tune into those. If you haven't received an email for registration with that, please reach out to us here at CCASA and we will provide you with that registration link. Thank you all so much for attending.
Thanks, everyone.
Thank you.
We'll talk to you soon.